Forensic auditors and criminal lawyers complement each other while conducting forensic investigations. Forensic auditors are seeking the facts, are looking for the truth in alleged misconduct or fraud. On the other hand, lawyers are supporting forensic auditors in establishing whether the facts constitute a crime or the circumstances may bring some release from criminal liability, both individual and corporate. So, in my opinion, especially in larger forensic investigations, in particular associated with crimes or alleged crimes that may lead to corporate criminal liability, I would recommend cooperation between the forensic auditor and the lawyer. Said that, I would like to give some justification for this statement. So first of all, forensic investigators are specifically trained for discovering facts, for preservation of evidence, and for conducting forensic activities during the internal investigation, being, for instance, structured interrogation or structured interview of a suspect or suspected perpetrator of misconduct. This training is a core competence of forensic auditors and is not necessarily so core for criminal lawyers who are more specializing in or more trained in understanding the legal context of forbidden acts, are more trained in assessment of facts according to the ancient Roman rule da mihi factum dabo tibi ius, which means give me the facts, I will give you the law. This is what was happening in courts, but obviously prior to submitting any claims to the court or submitting any claims to the public prosecutor's office, it's worth to establish whether there are grounds for belief that the alleged fraud or misconduct took place, and that this alleged misconduct in fact constitutes a forbidden act being subject to criminal liability or potential criminal liability, because the decision about the liability lays as usual with the court of law, and whether there are no circumstances that may release a person who committed the act from the liability, because, for instance, the person was not aware that her action was in fact forbidden by the law, because, for instance, they were not trained by the employer or not ready to execute specific roles. And in this respect, in this context, it may be worthwhile to consider whether the actual misconduct should be reported to the law enforcement if it's not required to report, or if it needs to be reported, what conditions we may need to consider before we go to the public prosecutor's office with our self-disclosure about the misconduct that took place within our corporate entity. I myself specialize currently in this legal support of forensic investigations, so I'm supporting forensic auditors in assessment of the facts established during the internal investigations. assessment in the context of potential criminal, civil, or administrative liability, and any potential or available line of defense if needed in case of potential corporate criminal liability, risk of such liability, or if we need to assess whether the action of the manager or a person who committed the misconduct, whether this person may actually in fact be liable to criminal, civil, or administrative fine or any other negative consequence deriving from the commitment of forbidden act. In the past, obviously, I was also involved in running the internal investigations. I was a young lawyer specializing in forensic sciences, and I was engaged in interviewing, training, engaged in supervising electronic data discovery, preservation, review, and presentation of the outcome of the review in criminal or civil courts. And now, being equipped with this experience, decided to support my younger colleagues or forensic auditors who did not wish to pursue the law practice experience. I'm supporting them with concluding the outcome of a forensic investigation and the considerations regarding the follow-up actions and any necessary improvement actions to be taken as a result of the facts established during the investigation. I'm also helping them to challenge some of the facts established during the internal investigation and potential omissions that took place during these investigations. And this happens especially when someone is very much dedicated to conclude around the alleged misconduct in a short time frame and with pressure from the client. Having this decision-making process split, decision-making about conclusions, split between the forensic auditor and the lawyer lessens a bit the pressure from the client and helps actually to seek the truth instead of a plausible outcome expected by the client. Because the client, at the end of the day, in his best interest is also to establish the true state of the facts instead of some theory confirmed by some of evidence collected during the investigation, but bypassing other evidence proving otherwise, and this actually never helps to solve the problem, although sometimes it's kind of very welcome in closing the case. And in order to avoid this pressure as an auditor, I decided to move on and change my jersey to the legal advisor jersey and being criminal law lawyer supporting the auditors, not the auditor supported by the lawyers. And in my opinion, this mix of experience and education may be very valuable in resolving allegations of crime or misconduct. So if you would be interested in receiving some support from a former forensic auditor, being now criminal law lawyer and criminal compliance lawyer, feel free to reach out and contact me. I'm happy to respond to any follow-up questions and inquiries. In the meantime, thank you very much for bearing with me, and let's keep in touch.